Greetings. My name is Dr. Perry Lau. I'm a professor of criminal justice at Columbia College in Orlando. When do police have the authority to use deadly force? Now that's a question that all police officers must thoroughly understand and be able to articulate. Criminal justice and social science students as well need to understand when police can use deadly force, how the laws evolved over a period of time, and how their local police operations may intersect with the community. The Supreme Court of the United States gave us two landmark decisions back in the 1980s to help clarify police use of deadly force. The first was Tennessee versus Gardner, 471 U.S. 1, decided in 1985. In that case, police may not use deadly force in order to prevent the escape of a fleeing felony suspect unless the police have probable cause to believe that the suspect poses a lethal threat or serious injury to the officer or to others. It's commonly referred to as defense of life standard. Police acting on a prowler call found the suspect in a neighbor's yard trying to escape by climbing over a fence. The officer shining his light on the suspect determined that the suspect was unarmed. Gardner refused to obey the officer's command to halt. Firing a shot at the escaping burglar, a bullet struck the suspect in the back of his head and he later died at the hospital. Gardner was found to be unarmed and just 15 years of age. He had only a woman's purse and $10 on him. The court summarized, where the suspect poses no lethal threat to the officer or to others, the threat of failing to apprehend him does not justify the use of deadly force. The Memphis police officer was acting within Tennessee statutory law at the time of the incident. The Supreme Court's decision from that point on made the Tennessee law unconstitutional. Graham versus Connor was decided in 1989, and Scott has found that police may not be held liable under the color of law sections, Title 42, Section 1983, for the use of excessive force. The new law established objective reasonableness rather than substantive due process. Graham, a diabetic, had asked a friend to drive him to a local convenience store as he felt the onset of a diabetic episode and wanted to purchase some orange juice. Barry, the driver, pulled in front of the convenience store, whereupon Graham got out, went inside the store, and found the lines to be too long. He then rushed back out of the store, got into the car with Barry, and the two of them sped off. A police officer witnessing these events became suspicious and followed Graham and Barry. The pair deemed to be suspicious were pulled over, and other backup Charlotte police arrived at the scene. Graham pled with the officers, exited the vehicle, and ran around the car twice and sat down on the curb and proceeded to pass out. Graham, when he came to, found himself lying face down on the ground and handcuffed. The officers scoffed at Graham and Barry's claim that he was diabetic and seized Graham, slamming him face down on the hood of the police car, and then placed him inside the cruiser while investigating the suspicious activity back at the convenience store. Police later released Graham, finding no issue at the store, and took him home. Graham sustained several bruises, a broken foot from the altercation, and filed a civil rights action against Connor and the police department under Section 1983. The new law nullified whether or not the police officer acted in good faith or maliciously as substantive motivations. Hence, the court determined that the officer's actions must be judged by objective reasonableness in real time as they occurred and not in 20/20 hindsight. The court found that the officers reasonably believed, in light of the circumstances, that a crime was afoot and that they were trying to prevent it. Now, under Title 42, Section 1983, police are found liable when their actions are judged to be punishing and not within the bounds of objective reasonableness to seize and secure a person to be held account for their actions. The court found in favor of Connors in this case and sent it back to the lower court to be judged on objective reasonableness of the Fourth Amendment. Now, as we all know, vehicles can be used as deadly force objects as well. In Scott versus Harris, decided in 2007, Scott has found that Harris, a Georgia County deputy, actions were justified when he terminated a high-speed chase of Scott, who had multiple opportunities to terminate the pursuit and submit to the police, who had chased him for miles at high speeds, putting himself, the officers, and innocent bystanders at risk of death and great bodily harm. The bumping of Scott's rear fender, known as a pit maneuver, caused Scott to lose control of his car. He crashed, and whereupon he received multiple injuries and later rendered a quadriplegic. The court ruled that the deputy's actions did not violate the subject's rights under the Fourth Amendment, even when it places the fleeing motorist at risk for injury or death. Police officers do not violate clearly established federal law when they use what amounts to as deadly force during a high-speed chase. They are not civilly liable under the law. It is important to note, however, that if the police agencies impose a stricter policy on the use of force, in civil litigations, the courts will generally hold the officers to the more restrictive standard. The job will likely be in jeopardy if the officer exceeds departmental policy. On the criminal front, the prosecutors will evaluate the case and follow the statutes and constitutional law. Now, as a companion to what was just previously discussed, another question always seems to arrive, and that is, can police order you out of your car? The answer to that is yes. Let's look at a 1977 case in Philadelphia, wherein two Philadelphia police officers stopped Mims for a traffic stop. The officers became suspicious of his behaviors and ordered Mims and his passengers out of the vehicle during a routine stop. Mims was noticed to have a bulge in his jacket, and upon pat down, the police found a concealed weapon, which Mims had no lawful permit to carry. He was arrested and his weapon seized. The Supreme Court had upheld a lower court's decision to exclude the weapon and dismiss the case. However, Scottish, in review of this case, sent the case back to the lower court, the Pennsylvania State Supreme Court, and by this established wide support for police officer safety. Now, a final case for review has some ring to it, as the Michael Brown and Darren Wilson case in Ferguson back in 2014. Listen, if you will. Henning and O'Leary. In this case, the two officers were confronted in a situation where the suspect was unarmed, but trying to obtain the officer's weapon during an altercation. While the suspect had not actually obtained the weapon, the subject was acting in a threatening manner, and the court found that the officers acted reasonably when they shot and killed him while trying to handcuff the arrestee. The court commented back then, officers are not required to wait to take action to protect their safety until a resisting arrestee has completely freed himself and attained a firm grip on a weapon. so the court commented. Now, I plan to do 10 of these public safety leadership discussions, and I hope that in this particular discussion you found the information useful. I hope it may have clarified some of your questions and concerns about police use of deadly force, and if you found that the information has provided you better insights, please give me a thumbs up at the bottom. Please start a dialogue, as I love to hear your comments. Just remember that charging a police officer when killing a civilian is extremely rare. What the public sees in crossing the line may not actually break the law. There are plenty of guidelines for the use of deadly force, but it all boils down to what the officer believed when the force was used. Thank you for your attention to this discussion, and I look forward to seeing you soon. Good day.